The new FTX CEO, John J. III, issued a scathing assessment of unprecedented poor management practices by his predecessor, Sam Bankman-Fried, in a series of bankruptcy court filings, saying, "Never in my career have I seen such a complete failure of corporate controls and such a complete absence of trustworthy financial information as occurred here." Joining us now to discuss is Daniel Gwen, counsel in Ropes and Gray's Business Restructuring Group. Welcome, Daniel. So I imagine in your career you've seen a bit of restructuring or two, but maybe parallel to John J. Ray, you've never seen anything like this before.
Yeah, good morning. And, usually when you file for bankruptcy, the companies are never in perfect condition. Otherwise, you wouldn't be filing for bankruptcy. But from what John's described, there's been a lot of corporate oversights and corporate failings that have kind of led us here today. So it's a little bit shocking to see. I'm sure John will do a great job sorting all it out, but it'll take some time.
So there was a Chapter 15 filing. There's a Chapter 11 filing. Can you explain the differences for the kids at home who aren't on Wikipedia? And why would FTX go through all that?
Yeah, so basically, FTX is domiciled or located in a bunch of different places, some of it in the United States, some of it overseas in Antigua, Bahamas, and other places. FTX Digital Markets, or marketing, is basically a Bahamas-located entity. They filed for the insolvency protections under Bahamas law, and they sought recognition, meaning they sought approval, in a way, from the U.S. courts in New York. The rest of the FTX corporate entities were Delaware entities, or mostly Delaware entities, or have jurisdictions or at locations in Delaware, such that they could file in Delaware. And so that's why there's kind of this bifurcated structure where some of it's happening in Bahamas, some of it's happening in the United States. The long and short of it, the fight is basically trying to consolidate everything into a single place, either in Delaware or in Delaware, New York, and Bahamas. But I think that's going to be sorted out by the bankruptcy courts.
What do you make of these shifting jurisdictional challenges? So why make all the effort of FTX incorporating in the Bahamas, then filing for bankruptcy in the United States, and then trying to make filings, Chapter 15 filing, to get those assets and protect those assets away from the United States in favor of the Bahamas? What do you see as going on there?
I wouldn't read too much into it. I think these are probably set up in various places for non-bankruptcy reasons, sometimes for tax reasons, sometimes for other reasons. And no one really thinks about this kind of stuff thinking, okay, I'm going to set this up for a bankruptcy 4 years from now. They're kind of just doing it for other reasons, and then things happen as they happen, and here we are today.
Okay. So now in the filing, there was mention of misuse of corporate funds. Reportedly, there was software that was created to change the corporate books without alerting the accountants, and a secret exemption for Alameda to, prevent them from being auto-liquidated. Like the rest of the users on FTX, Alameda was kind of given a special exclusion where if they made a bad trade, everyone else would get liquidated except Alameda. These kind of things, like how would they impact a bankruptcy filing, if at all, or is that just totally something that would go to like a criminal charge?
I think John kind of outlined in his declaration that he's taking a close look at these procedures and policies and making sure they're right for the circumstances. I don't know what right is for these companies, and maybe there's a good reason for that kind of exemption, maybe not. But I think he's just trying to take inventory of what's going on, figure out where the fires are, and trying to put them out. If it's true that these procedures are in place and they were not appropriate, then I think John and his team will probably figure out a way to put out the right procedures. Whether they lead to criminal charges. Oh, go ahead, please.
Daniel, you were saying whether or not it leads to criminal charges. I assume you're going to say that remains to be seen. Now we have Mt. Gox happened it was like a decade ago, and people still haven't gotten paid back yet. Is that what we might expect in this case? That it might be until the 2030s before account holders will get paid back, or are we going to move faster in Japanese courts?
Yeah, I think you alluded to this. These are Japanese courts, or Mt. Gox was administered under the Japanese court, under Japanese insolvency law, so it's a different kind of apples and oranges situation. But in terms of U.S. comparisons, you have obviously the Bernie Madoff type scheme, which is kind of a little bit different, the Lehman Brothers type scheme, which is a little bit different. Those also took months and years to kind of resolve. And as part of that, there's a lot of untangling of the web. There was a lot of litigation and kind of brought a lot of intercompany fights too. All of those things were borne out and are still going on in Lehman and in Bernie Madoff. So I think you're absolutely right. This is going to be measured in months and years, not weeks and months.
What are the next steps in this bankruptcy process for FTX?
I think the next steps are, number one, take inventory of what you got. I think John's still trying to figure out what is going on all these different places. Number two is figure out what's missing. I think, as you saw, everything in the first day declaration, he says, take with a grain of salt. I've found these in somebody's books and records, but I don't know if they're accurate. And number three is just maximize value. I think he's alluded to this in his first day declaration, but there could be litigation against SBF. There could be a sale process. He's in the process of retaining an investment banker. But I think from there, it sounds easy to do, but it's a tall order.